there is effectively a new bill in California for website and mobile app accessibility. But what is significantly different about this bill versus any other law or piece of legislation I have seen is that this bill would potentially apply to developers, designers, creators of digital assets that are incorporated onto websites and mobile apps. So I've got the actual page for the bill pulled up, and I'm going to link to this below. But I want to read from a few selections to bring this forward and to show you that the bill actually applies to these different entities that are working on digital assets. And it says, the following parties may bring a civil action pursuant to this subdivision: a person who is unable to obtain equally effective communication or full and equal enjoyment of an internet website. Two, a person or entity that pays, compensates, or contracts with the resource service provider to construct, license, distribute, or maintain an internet website for the purpose of providing equally effective communication or facilitating full and equal enjoyment, etc. And then later on the page, it says the following terms have the following meanings. Resource provider means a person or entity that, in exchange for money, constructs, licenses, distributes, or maintains for online use any internet website or resource to be used within or in conjunction with an internet website. So that has far-reaching implications. And one thing to note right away is that you, as a developer, designer, etc., product seller, etc., you could potentially be sued by both a person with a disability and the website owner or the mobile app owner who is integrating your product or your widget or your integration, whatever it is, or is using your services to make their website or to build their mobile app. So far-reaching implications. And I know this bill is specific to the state of California, but it applies broadly because someone who is in California can can bring action under this bill for if they've accessed for whatever business they've accessed. And so in this case, because websites and mobile apps can be accessed from essentially anywhere, so someone in California could bring suit against you even though you're in another state or in another country. I think it's more likely that someone would be sued inside of the United States, but it's certainly plausible that someone outside of the United States could be sued. So this bill is still only proposed. It has not been approved, and I am recording this as I have found out about the bill on June 21st, 2023. So there is at least 3 months before this could potentially go into effect. My hope is that this bill is not approved because there are so many details that need to be worked through. I am definitely pro accessibility, but I think if you are going to establish a formal legal precedent, then you need to do it the right way. And there are so many things that are glossed over here and so many nuances that need to be considered. Really, this bill, what it does is it enables plaintiffs' law firms to bring even more litigation and to find even more technicalities. And really, it gets away from the purpose, which is ensuring access to people with disabilities. And then we get into this game where we are arguing different technicalities. And so what is required under this bill is WCAG 2.1 AA conformance. So I know this could be viewed as negative news, but here is an opportunity to embrace accessibility and also get first mover advantage. So within your space, you may be the second or third or fourth provider that people think about. First mover advantage would involve you being the first provider to embrace digital accessibility and really go all in on accessibility and WCAG conformance. Um, get training on it, and work it into all of your processes, and really bring on accessibility consultants and really become through and through a company that prides itself on accessibility. And so this can be whether you are a digital product provider, whether you are a website builder, whether you're a website designer. If you start embracing accessibility and then marketing that, it can be a boom for your business. And so, whether or not this bill ends up being approved and becoming law, a digital accessibility law is forthcoming in the United States, and it will not be that long until it has arrived. So, for you as someone who is potentially implicated, I know it may be a surprise that as a developer who is not even not even potentially the direct end provider. You're not the one that is actually the owner operator of the website or the mobile app. But now you have been implicated. But now is the time to just go ahead and embrace this and use this as an opportunity, and it really make it a win-win by being aggressive with accessibility. So invest in training, invest in consultants, invest in learning this as much as possible, and when you do that, then you can really be a leader in your own respective spaces, whether it's a type of software, whether it's you're a platform. If you would go ahead and embrace accessibility and really hang your hat on making sure to incorporate the web content accessibility guidelines and all you do, and granted, the WCAG is for the web, but the principles of accessibility are going to apply broadly to all digital assets. So when you embrace WCAG, you are going to go much further along and be ahead of any potential legislation. But this does also, you have to, if this bill were to pass, significant litigation would result from it. And there is already significant litigation around website accessibility. So it's something that you should already be aware of and you should already be embracing. But if you haven't yet, I recommend against the wait and see approach. I recommend the proactive approach and investing in accessibility right now. And some offerings that I have include the WCAG course. So I will link to that below. This course trains your team on accessibility. You can learn about it as you go. There are video explanations. I also recommend my ADA compliance course. This course tells your team how to find and fix accessibility issues, and it also prioritizes issues by the likelihood that a claim could arise that would give rise to litigation. So the lessons are the most commonly claimed accessibility issues in litigation by the most active plaintiffs' law firms or plaintiffs' law firms that are new to the space. That course has everything prioritized. All of the lessons are in it. And so you can start there, lower the risk of litigation for anybody involved by incorporating those accessibility issues, and then start there and then work towards full WCAG conformance. Because WCAG, with WCAG, there are several requirements to meet the technical standards, but the way in which you approach becoming conformant can significantly reduce your risk of litigation. So you might as well reduce your risk of litigation as you go. And I will link to the ADA compliance course below. But the important takeaway here is that this is a proposed bill that could, in fact, become law. And if it does, it directly implicates developers, designers, and those who provide digital products that can be integrated into websites and mobile apps. So there are far-reaching consequences, and to go ahead and take this from something where it becomes something of a risk, you can actually go the other way with it and turn it into a business opportunity, because the business opportunity is there and accessibility is always the right thing to do.